Welcome to this explainer, where we're jumping right into the ticking clocks and tactical maneuvers of an intense Arizona civil lawsuit. When we think of lawsuits, we usually picture dramatic courtroom showdowns, surprise witnesses, and impassioned speeches, right? But the reality? The real war is almost always waged in the documents. It's a highly structured, tightly regulated game of strategy, deadlines, and procedural posturing. Today, we're going to unpack a fascinating collection of case filings for Maricopa County Superior Court, spanning from February to April 2026. By digging into these raw primary documents, we'll reveal the true anatomy of a civil lawsuit and watch a high-stakes procedural chess match play out right before our eyes. It absolutely proves that in the real world, the most lethal legal weapons are usually just deadlines and paperwork.
All right, so to help us navigate this maze of legal filings, here's our quick roadmap. First, we'll look at the summons and stakes. Second, the battles over legal service. Third, the race for a stay. Fourth, motions to dismiss. And finally, we'll tie it all together with the overall procedural chess match.
Okay, let's dive right into Section 1, the summons and stakes. Basically, the starting gun. The sheer weight of the bureaucracy right out of the gate is pretty staggering. We start with an official Arizona Supreme Court summons issued on February 26, 2026. This is what establishes our immediate ticking clock. The document explicitly warns the recipient that their rights are affected. Once this paperwork is formally served, a defendant has exactly 20 calendar days to respond if they're within the state. If they just shrug it off and ignore it, no way. They risk losing the entire case by default. This single piece of paper instantly transforms a theoretical disagreement into a legally binding countdown.
But before we watch the actual plays unfold, we need to know who's on the field. On offense, we have the AZNH Revocable Trust, represented by John and Susan Sullivan. They're the plaintiffs driving the action here. On defense, they are taking on a massive multi-front battle against two state administrative agencies and a private entity. Specifically, we're talking about the Commissioner of the Arizona Department of Real Estate, the Interim Director of the Arizona Office of Administrative Hearings, and finally, the Sunland Springs Village Homeowners Association. So yeah, it's a pretty complex web of public and private defendants.
Moving on to Section 2, battles over legal service. This is where we see notice versus formality.
Getting the paperwork officially into the hands of the defendants sparks our very first major procedural skirmish. You literally can't just sue someone in secret. The court demands absolute proof that the defendants actually know they're being sued. While the law does allow for some flexibility, when tensions run high, the method of delivery itself becomes a huge point of contention. The plaintiff understandably wants to move fast, but the system often demands rigid formality. And we see a fascinating contrast play out with the delivery methods. On one hand, you have the plaintiff's attorney firing off quick emails on Friday, February 27th to the state agencies and the Attorney General's office. He notes that because of the short notice by the court, an email is the most expedient method. But then, fast forward nearly a month later to March 23rd, and you have a totally different approach, a rigid declaration of service showing an official licensed process server physically delivering a stack of documents to the legal secretary at the Office of Administrative Hearings, complete with a $90 service fee. Because, well, sometimes the legal system insists on paying someone $90 to do what a free email did weeks ago. But to the court, that physical delivery leaves zero doubt that service was completed. It really shows how even the earliest stages of litigation can become deeply adversarial. The animosity noticeably spikes in a March 5th filing. The plaintiff files a reply accusing the Attorney General's office, who, remember, represents the state agencies, of filing a notice about past cases for a completely improper purpose. The plaintiff argues the state is bringing up unrelated, old litigation strictly to muddy the waters, give the court a bad impression, and frankly just harass or annoy. They firmly state these past events have absolutely no relation to the current case, so the chess pieces are already aggressively colliding. Which brings us to Section 3, the race for a stay, or, in other words, desperately trying to pause the action. You can really feel the tension escalating when you map out the dates here. The plaintiff isn't just fighting in Superior Court. There's a simultaneous track running at the Office of Administrative Hearings. On March 20, the plaintiff claims to discover new documentary evidence from the HOA. This triggers a frantic race. Just 4 days later, they file a restated request for a stay. They know they have a show cause hearing coming up on March 27, but their eyes are fixed on a huge looming threat, an administrative hearing scheduled for April 6th. The plaintiff is practically racing against the clock to get the Superior Court judge to freeze everything before that April 6th date arrives. So what exactly are they racing for? A stay. Think of a stay as a legal emergency brake.
The plaintiff is begging the judge to pull this break before the administrative hearing happens. They argue they've been deprived of a substantive procedural right, and if the April hearing goes forward, they'll lose a benefit that literally cannot be fixed later on appeal, namely, the benefit of avoiding litigation entirely. They are essentially asking the Superior Court to reach over and just hit the pause button on another agency's calendar.
Section 4. Motions to dismiss. This is where the defense strikes back. Okay, to understand the defense's pushback, we first have to understand the core of the plaintiff's argument. In legalese, this is called the gravamen, the actual essence of the grievance. The plaintiff claims the Department of Real Estate Commissioner unlawfully withheld a mandatory default decision. Basically, they argue that because a respondent didn't submit a response to a petition, the commissioner had absolutely no discretion and was statutorily required to rule in the plaintiff's favor. They strongly believe this specific failure by the commissioner is what forced them into this entire messy lawsuit to begin with.
But the defense isn't having it. On April 8, the attorney for the Homeowners Association files a reply in support of a motion to dismiss. And their language is very deliberate. They assert that the plaintiff's complaint fundamentally fails to state a claim for which relief can be granted. The HOA is basically saying, look, even if the plaintiff's version of events is 100% accurate, they still wouldn't be legally entitled to the relief they're asking for. It's a classic, heavy-hitting legal maneuver. Don't just argue the facts, argue that the underlying legal theory itself is fatally flawed.
Finally, Section 5, the procedural chess match. Let's look at the grand strategy. When you zoom out and look at the strategy as a whole, it really is a structured game of cause and effect. Every single motion demands a countermotion. The plaintiff opens the offensive with the summons and those aggressive requests for stays to halt outside proceedings. The defense parries that, not just by answering, but by deploying defensive countermeasures. They use the Rule 3.1 notice to contextualize the plaintiff's past behavior and then drop the ultimate defensive block, the motion to dismiss, trying to wipe the lawsuit out entirely before it even gets close to a trial.
So as we wrap up this explainer, the ultimate question remains up in the air. We've seen the quick emails, the official process servers, the frantic attempts to freeze the clock, and the heavy-handed motions to throw the whole case out. Amidst all these ticking clocks and accusations of bad faith, whose legal strategy is the judge actually going to validate? Will the plaintiff secure their emergency brake, or is the defense going to successfully collapse the entire case? The documents show us all the moves, but only the judge can declare checkmate. Thank you so much for joining us to unpack the procedural anatomy of this fascinating case.